Okay, welcome everyone to the spaces regarding the Moderna versus Arbutus patent appeals oral arguments that we just finished listening to. I'm joined today by IP Hawk and Gaston Krubb of Markman Advisors. So the three of us are going to discuss what we just listened to and what impact we think the outcome may be, what impact it might have on the relevant companies. Just as a high overview, these appeals by Moderna are of lower decisions by the patent office in administrative challenges called IPRs that Moderna made to two separate Arbutus patents. In the first challenge, the patent office ruled some of the patent's claims were invalid and others were not. Moderna appealed that decision to not invalidate all of the claims, and Arbutus cross-appealed the decision to invalidate some of the claims. In the second patent challenge, Arbutus won across the board. The patent office ruled all of the claims in the second patent were valid. So Moderna has appealed that decision. There were two main issues argued on appeal that you may have heard mentioned. One is standing, and the other is the merits. So standing is a requirement to file a case in a federal court set forth in the Constitution. You have to have a case or controversy. There has to be really a real dispute with immediacy. And Arbutus argues that there is no standing for Moderna to appeal the patent office decisions. As a footnote, there is no requirement for standing in an administrative proceeding. So Arbutus's first argument is Moderna's appeals should be dismissed out of hand because they don't have constitutional standing to come to court and ask the court to overturn the patent office's decision. And a lot of the discussion we just listened to is about standing. Then on the merits, there was lots of scientific discussion about whether or not what is claimed in the patents was either anticipated by or rendered obvious in light of the prior art. Those are two separate requirements to have a valid patent. There's a long list of requirements to have a valid patent. Two of them are that what you claim was not done previously or was not anticipated. And another is even if what you've done is new, it must be so new that it would not be considered obvious by one of ordinary skill in the art. So with that overview, I'd like to turn it over first to David, IP Hawk, who I hope everyone follows, for his thoughts and analysis on the relevance of these appeals.
Before I start, I don't think Gaston his microphone on, so hopefully he's still here. I'm on. I hear you guys. Okay. All right. Good. So Arbutus, $400 million market cap. I believe they have a bunch of different programs in process. They had a license with Moderna. No litigation has been filed yet. I would be betting that based on the decisions from the federal circuit will indicate if they're going to file suit. It's not really clear what Moderna might do. They're obviously the big COVID vaccine manufacturer throughout the world at this point. That's pretty much it. I thought the hearing was really interesting, more complicated than most of the other ones that I've heard, especially on standing, which isn't really brought up too much. Most of the issues from the PTAB are, on the merits, obviousness, anticipation with the prior art.
Great, thanks. Yeah, unfortunately for me, the leading case on standing to appeal patent office decisions, which was mentioned during the oral argument, is called Consumer Watchdog. That was my case, and I lost on appeal because the Court of Appeals found my clients did not have standing. So standing to appeal patent office decisions is an issue near and dear to my heart, for better or for worse. Gaston, thank you for joining us today. What thoughts do you have, having now listened to the oral arguments?
Sure thing, Dan, and I know we can't win them all, so it's at least good to know that one of the cases you were involved in was is still being discussed. So I thought it was a very interesting argument. Clearly clearly the market dynamics are very interesting here, and they're actually very relevant to what I think was a lot of the questioning on standing, right? And the key focus I thought was on is there enough in the evidentiary record to suggest that Moderna, that suit against Moderna was imminent? And I think that there's a little bit of a trying to cobble together of enough facts to generate standing that Moderna was trying to do. And in contrast, I actually thought that Arbutus' lawyer did a very good job of putting the case in the bucket of you've decided this before Federal Circuit, and specifically the argument about, well, this case, in the Samsung case you found standing, in the Apple Qualcomm case you didn't find standing, and we're more like Apple Qualcomm. I thought the way he structured that argument was very effective. In terms of, do I think there's enough here for the Federal Circuit to even address the issue of standing in a decision? I think there is. It seemed to me that at least Judge O'Malley was very interested in probing the limits of what standing would be. At the same time, I didn't get a lot of the sense that the Federal Circuit panel was willing to disturb the board's findings on any of what we're terming the scientific issues. So I think there's at least some chance that these decisions from the panel to stand rubber stamped, or what we call Rule 36. But if I had to predict, I'm leaning Arbutus based on this argument, and I'm expecting an opinion in the next few months, maybe as much as 2 to 4, 6 months out, addressing the standing questions, if that's the way they want to go. I actually think the timing is very relevant here, because I agree with David's point. It does seem to me that Arbutus is waiting for the result of this Federal Circuit decision, as I would tell them to do if I was representing them, in order to formulate or finalize their legal strategy vis-a-vis suing Moderna on the COVID vaccine. So to the extent this decision comes quicker, I think that might accelerate Arbutus' next step. And to the extent the decision is delayed, it may lead to a longer wait to see, for those Arbutus followers that are interested in seeing them go after Moderna in a more rigorous way.
Thanks. Yeah. Let's be clear about that. If people are asking why hasn't Arbutus sued Moderna yet? Well, they have a license agreement. I haven't gone and looked at it. It may be redacted. There may be dispute resolution processes set forth in that agreement, perhaps even arbitration. So Arbutus may not have the right to file suit, given they're already in a contract with Moderna. Secondly, even if they had the right to file suit, if Arbutus was to file a lawsuit against Moderna, Moderna would use that fact to support its standing to challenge these patents. And so if it's important to Arbutus to get the patent office's decisions upholding their patents affirmed, they don't want to help Moderna have standing to appeal by suing Moderna. So this is not unexpected. It's not a sign of weakness for Arbutus that they haven't sued Moderna. It's exactly what I think Gaston and I would each advise them to do. So let's talk from a high level what's likely to happen here. The Federal Circuit generally, roughly 80% of the time, in appeals of patent office decisions, affirms. So just off the bat, Arbutus is a heavy favorite. 80% of the time they affirm. Half of the time the Federal Circuit affirms, they issue the rubber stamp Rule 36 affirmance within a few days that Gaston mentioned. So 80% of the time they affirm. Half of the time when they affirm, they do a rubber stamp Rule 36 affirmance within a few days, if not a few weeks. If they don't affirm with a rubber stamp, they'll then write an opinion over the course of the next few months explaining why they affirm. In the other 20% of cases, roughly 10% of the time they reverse, and roughly 10% of the time it's a mixed opinion where they affirm on some things, reverse on others, what have you. So that's the Federal Circuit's generally speaking. Now, there are three specific judges amongst the Federal Circuit assigned to these appeals. So when you have an appeal at the Court of Appeals, you do not get heard by every single judge on that court. This isn't like the Supreme Court, where every justice hears every case. At the Court of Appeals, there's a bit of luck involved, or bad luck, in my case, however you want to say it, regarding which three judges you are assigned to hear your case. And that isn't known until the morning of your argument. They don't tell you in advance. And there are differences of opinion on many issues, including standing and obviousness and other issues amongst the Federal Circuit judges. Just like there's a difference of opinion amongst the justices of the Supreme Court on issues like abortion, gun rights, religion, etc. These are human beings. They have different opinions. Some on the Court of Appeals for the Federal Circuit are Obama appointees and some are Bush appointees. It's coincidentally, I think, the only Court of Appeals that does not have a Trump appointee. So the three judges on these appeals were Judge Lori. He's one of the oldest judges on the court. He was a former in-house lawyer for GlaxoSmithKline. He is generally, in my opinion, very pro-pharma patent. So that means he likely would lean more towards Arbutus than he would towards a challenger to Arbutus's patent like Moderna. Judge Stoll is one of the most recent additions to the court. She has a background from a very prominent law firm in DC, known for representing many big clients. She also, I think, would be generally favorable of patents. Her entire career, legal career, was built around the patent system. So she's not a skeptic of patents like some other members of the Federal Circuit are. The third judge, O'Malley, is a former district court judge who got elevated to the Court of Appeals. She's very rigorous. She was the one asking most of the questions. She doesn't have a patent background. She did hear some patent cases as a district court judge, and since being elevated to the Court of Appeals for the Federal Circuit, has gone out of her way to be a proponent of the patent system and its benefits. So when I woke up this morning and saw that the panel was Lori and Stoll and O'Malley, you couldn't ask for much of a better panel if you're Arbutus or the patent holder, the pharmaceutical patent holder in this situation. And so taking that, and in addition to the general facts, means it's very unlikely, in my opinion, that Moderna is going to win on both of these appeals, much less either one. And as a matter of patent law, Moderna has to be able to disprove that it infringes any valid patent at all held by Arbutus. If Moderna infringes a single patent that's not invalid, then Arbutus is due royalties. So Arbutus doesn't have to win on everything, Moderna does. So the odds are not stacked in Moderna's favor. So listening to the question...
Yeah, Dan,
go ahead.
Oh, go ahead. I just wanted to jump in there, Dan. I think it's important for the listeners to understand why Arbutus would want to wait to see if these IPR decisions are upheld. And it's an issue that came up during the argument itself, which is the question of estoppel. So as a challenger in the patent office, if I lose my IPR, if I lose my attempt to get the patent office to review and throw out a patent that already issued, that has carried through to any future infringement case or current infringement case that involves those same patents. Basically, you don't get two shots at it. Now, one of the reasons why challengers like to go to the patent office to raise these validity questions as opposed to doing it in district court is because it's a much more favorable forum for a variety of reasons that we don't need to get into. But the point is that if Arbutus wins now, that will hamstring to probably a large extent Moderna's ability to challenge the validity of patents in a later lawsuit because they took their shot at IPR and would have lost if the Federal Circuit agrees. I think it's because it came up in the argument, I think it's important to kind of point that out at this point.
Absolutely. As we would say, if your patent survives IPR, it is gold plated. I mean, before most district court judges and juries who are not scientifically inclined, they will generally give the patent office deference and agree with the scientific decisions of the patent examiner, or in this case, the PTAB judges. But when you've survived this type of a challenge, it's very, very difficult to get a judge or a jury later in any related litigation to say, well, the patent office granted this patent and then they reviewed it and approved it again. It's almost impossible to get that patent invalidated. Now, that doesn't mean Moderna may not have some kind of non-infringement argument to make in the future, and we'll have to see. But as Moderna was saying in the argument themselves, Arbutus has claimed in its vast patent portfolio the entire field of lipid nanoparticles. And so there was the mention of the Qualcomm-Apple litigation, Apple v. Qualcomm, because there are a lot of parallels, even though it's a completely different industry and technology. Apple is the famous company everybody knows, everybody has, just like Moderna. And then Qualcomm is this kind of unknown, huge patent holder that licenses its patents to commercial companies like Apple. And Qualcomm and Apple had a very successful licensing relationship for a number of years. Apple then threatened to walk away from the license. Qualcomm had to start suing them. And after a few years of wrangling, both at the patent office and at the Federal Circuit and in other courts, the parties again negotiated another license agreement. And I think that parallel, it was pretty ironic, coincidental, whatever you want to call it, that the Apple-Qualcomm dispute is so relevant on the legal issues in the Moderna-Arbutus dispute, because the relevant position of the parties is almost exactly the same. So on the merits, I think it's going to be very hard for Moderna to prove standing. Maybe I'm biased because I've lost on this issue and I feel their pain. I think this law of standing should be changed, but that's not what the law is, and we have to deal with what the law is. On the scientific merits, I don't see Judge Laurie, Judge Stoll, and even Judge O'Malley substituting their own scientific opinions for those rendered by the patent office. So I expect these cases will result in decisions in Arbutus's favor. That could be the rubber stamp kind of decision we mentioned, or could be a written opinion within a few months. David, what thoughts or additional comments might you have for the group?
So I think the 069 patent, which found all the claims not unpatentable, I know they used a double negative, but Moderna lost that one. I think that one has the best shot to be Rule 36 in the next 10 business days. I would say that's very likely in this situation. Just the burden on Moderna is very difficult, and from what I heard in the hearing, they just didn't have enough. There wasn't a smoking gun. On the 435 patent, you're probably going to see some kind of opinion on it. I wouldn't be surprised if it was remanded back to the patent office, one way or the other. At that point, I don't even know if it matters if the 069 patent, is upheld. I don't think that Federal Circuit will address standing. They'll leave it alone. I think any opinion on the 435 patent should be pretty quick, maybe in that 3 to 4 month timeline. There's just to add something else. There's going to be another patent issued to Arbutus on Tuesday, a child patent from this same patent family. So any of these issues and prior art issues that might have been a problem for Arbutus are probably cleaned up in this patent. That's probably something for people invested in the situation to really look at.
Great. Yes, absolutely. Arbutus has more patents being produced, more applications in the pipeline. So they have very competent patent counsel, and they are executing a very comprehensive campaign to build up their patent portfolio around everything related to lipid nanoparticles.
More specifically, real quick, they filed 5 child applications to the 435 patent, which were all rejected and abandoned. They filed the sixth on, that was published, I think, April 12th, 2021. So it's post-COVID. This is the first one, that's really post-COVID. And this one that was allowed and will be issued on Tuesday, October 12th.
Fantastic, thank you. Gaston, any last thoughts or comments from you, please, sir?
Yeah, no, I think it's, just thinking in my head, how would I visualize the relative positions of Arbutus and Moderna at this point? And what popped into mind was like the light-in before a big boxing match, right? So they're staring each other down. They've gotten into shape. They're ready to go, but the fight is still for another day. And I think that's ultimately, where the likely result is here. So I do expect that Arbutus will prevail on the standing issue, which would result in which would result in potentially no decision on the merits here, but securing the IPR win. And then just as a kind of inside baseball for people that maybe haven't practiced in front of the federal circuit, it's very telling when going back to when we started at 10 o'clock this morning, when Moderna's lawyer first stood up, I believe it was George Lurie said, let's go straight to standing, right? That's the federal circuit's very cognizant of the fact that apparently, that the advocates have a limited time, and when they direct you to a issue to start off and tell you to start with that issue, that's very telling that that's what's on their mind, and that's likely to be the bulk of what ultimately gets decided.
Great. Well, please, again, thank you everyone for joining us today. Please give David IP Hawk a follow, give Gaston a follow, and Markman Advisors a follow. If you have questions, I know David and Gaston love talking to people about these issues, as do I. I believe all of our DMs are open. You can feel free to send us emails if you're boomers like us. David, you're a millennial. So if you're a boomer like Gaston and I, you can send us an email. And we look forward to updating everyone when the decisions are issued by the court. Thanks again, everyone. Take care.
Thank you.